Good morning, everyone, and welcome to this Evershed Sutherland PROPcast. I'm Heather Tomlinson. I'm a professional support lawyer to the real estate practice here at Evershed Sutherland. So our subject today is planning for change and considering what's on the horizon for planning in 2026. I'm delighted to be joined this morning by Paul Maile, who is a partner and head of the planning and infrastructure and consenting team here at Evershed Sutherland. Paul, do you want to introduce yourself and the work that you and your team do?
Yeah, thanks, Heather. Morning, everyone. Great to be joining you and to see that we've got so many people interested in today's session. It probably shows just how important an effective planning system has become for many of our clients out there and the businesses within which they work. So a bit about my role. I head up a team of specialist planning lawyers across the UK. There's about 40 of us across the business, and what we do is we help our clients engage with the planning system, offering strategic advice on how to bring forward developments effectively, as well as navigating the regulatory regime around things like environmental impact assessment, compulsory purchase, and things like that. And we do that across the full sort of breadth of infrastructure and development sectors, so covering things like logistics, housing, energy, and transport projects. And that kind of means that we come into day-to-day contact with some of the issues that we're going to be talking about this morning.
Great. And you and your team are going to be busy this year, aren't you, Paul? Because 2026 is shaping up to be a big year in the planning sector. We've got the new Planning and Infrastructure Act. The government's also recently launched a new consultation on the National Planning Policy Framework, the NPPF. And so we'll get to that consultation and sort of the detail of the new law in a moment. But I think it's important for us all to understand how this has all come about. So where we were versus where we are now. So perhaps you could set the scene for us and just explain a little bit of the background that's led us to the new act.
Yeah, thanks. I mean, I think it's important to see what we're going to be discussing today in context, because we're aware that planning is an intensely sort of political function. And so understanding where these reforms sit within that political context is quite important to understanding how they might progress and how government intends to evolve them. So if we cast our minds way back 18 months to the general election in 2024, much of what Labour stood on had a pretty strong planning theme. I can remember being quite excited that planning was almost part of the daily conversation around some of the election broadcasting. So what Labour had committed to do was a number of things. It committed to delivering 1.5 million homes throughout the Parliament. It committed to driving forward progress to achieve the UK's net zero targets. It expressed its sort of desire to address social inequality through the planning system and placemaking and things like that. And it sought to drive investment and economic growth through development projects. And if you cast again our minds back, we can remember Keir Starmer championing AI, for example, and wanting the UK to become a world leader in AI, which requires development such as data centers. And so fundamentally, it was a manifesto to get Britain building not just homes and wind farms and solar farms and things like that, but also all of the infrastructure that goes on to support that development, such as grid improvements, water infrastructure improvements, and things to mitigate some of the associated environmental impacts. So, as I say, this was sort of focus on delivery. And I think fundamentally the government looked at the planning system and decided that it wasn't fit for the purpose of actually delivering what it wanted over the space of the Parliament. And the government's quite keen to make an impact and to change things over the course of the 5-year Parliament. So when it first came in, it did a number of things in a fairly short space of time. It immediately updated the NPPF, and they were fairly sort of minor changes within the context of its structure at the time. So it reintroduced housing targets, and it and it set up the standard methodology to assess housing need. It ended what was just over a 10-year ban on onshore wind in England and brought that back into the planning framework. And quite significantly, it introduced the concept of grey belt within considerations of green belt policies and a number of associated policies around that. It's also done a number of things on the infrastructure side. So we've seen updates to the suite of energy national policy statements. So those introduce the concept of critical national priority infrastructure for things that are low carbon. It's announced a review of the airport's national policy statement, which is currently moving forward. It's approved, I think, somewhere around 30 development consent orders for infrastructure projects over the last 18 months. It's set up the New Towns Task Force, which has considered prospects for a range of new towns across the UK, and that's reported. And it's recently brought data centres back into the brought data centres into the development consent order regime. So it has done a reasonable amount in what is really quite a short space of time. But what we're seeing now with the Planning and Infrastructure Act, I think, is the first piece of sort of significant legislative reform from the government, and something that was trailed in the King's speech back in July 2024, immediately following the election. That promised four key things, really, to get Britain building and accelerate that housing and infrastructure delivery that we talked about. So it promised to bring forward an act that would modernise planning committees. It promised to use development as a means to fund nature recovery, where both development and nature recovery were stalled. It would introduce measures to streamline infrastructure delivery and related policy making. And it also indicated some fairly limited compulsory purchase reforms around compensation. So often in the past, planning reform has sort of thrown things out the window and started again. The new act doesn't really do that. It looks at improving the current system, and I think it's probably quite a positive thing that it does that. If changes are too big, then it takes a period of time for people to even adjust to the change, and that creates inertia. As we said, government wants to focus on delivery, and so changing and improving the current system is probably a more effective way to go when it comes to that.
Yeah, and I just want to pick up on something that you said whilst you were explaining that to us, Paul. You said about the government felt it was faced with a system that wasn't fit for purpose. Can you just maybe expand on that a little bit and explain what was wrong with the current or the existing system and why it needed to change?
Yeah, I mean, I think, look, I've been doing planning law for sort of just over 25 years now. And I think over the course of that period, it's something that's become increasingly bureaucratic and complex. I think the current sort of situation as well is it couples that bureaucracy and complexity with simply more going on across a variety of sectors. In the past, you've had possibly a downturn in the housing market whilst there's been a drive to deliver energy projects, or housing coming back at a time when things like onshore wind were dropping off. I think what you're seeing now is progress across all infrastructure, housing, and other development sectors, and that's placing a lot of demand on the system. So we have seen developers want to bring forward their projects. That obviously makes a big demand on the consultancy services and legal services in order to bring those kind of projects forward. That's driven an increasing number of people into the private sector to support those projects, and that's also then caused challenges consequently for people in the public sector who need to respond to those applications. So people within planning departments at local authorities, people who work for key stakeholders such as Natural England, and fundamentally it's been a real challenge for the system to be resourced properly in order to respond to the demands on it. So I think what we're seeing now is government considering how can it work with the current system to try and speed those things up.
Okay. And we're going to get into the detail of the Act, but it is absolutely enormous, isn't it? It's 200 and odd pages long and lots of accompanying guidance and so on. We've only got a short session today, obviously, so we can't go into every aspect of it. So do you want to pick out for us what you see as the most important elements in this new Act?
Yeah, thanks. I mean, everybody be pleased. I'm not going to go through all 200 pages. Wouldn't wish that on anybody. But I think let's go back to what sort of the King's Speech, as I said, was trying to achieve, and we'll focus on some of those areas and whether this Act actually does that and the ways in which it does it. And I'll give you some thoughts about whether it is going to make things more efficient and speed things up. So. Let's focus on the first one, which was modernising planning committees. So what the Act does, and the Act sets up a sort of framework for doing these things. A lot of the detail and the implementation will then come forward in regulations, which will be published in due course. But as far as planning committees are concerned, the Act sets up a framework for a national scheme of delegation. And what that means is that there will be a directive process which says which schemes will go to be determined by planning committees and which schemes must be determined by officers. It will look to introduce rules around the size and makeup of committees, with the idea, I think, that smaller and more focused committees should improve the speed and quality of decision making. Many people will be familiar with the experience of sitting in a large planning committee with everybody wanting to have their say, decisions, those committees going on for hours, often with decisions delayed or deferred. I think the idea is that smaller focused committees will speed up that decision making. So that's the idea around planning committees and giving more responsibility for officers to bring forward those things. If I then move on to nature recovery is probably the most intriguing element that's in the Act, because the Act establishes something called environmental delivery plans. Now, the aim of those plans are essentially to provide strategic compensation projects to overcome habitats regulations issues around things like nutrient neutrality or phosphate neutrality, which has been holding up lot of development, particularly in the south of England for many years. The way the habitats regulations work is that those schemes can't receive consent until those until there's a scheme for solving those issues in place. So lots of things have been held up. But under these new proposals, Natural England will have the power to bring forward environmental delivery plans, which will apply to a specific area and a specific type of development within that area. And then when developers bring forward projects which fall within the scope of each one of those environmental delivery plans, instead of going through a habitats regulations process, what they can do is pay a sum of money into what's termed a nature restoration levy, in basically in lieu of that assessment process and those provisions. Now, we don't know how much that levy will be at the moment. It's going to be set on a sort of site by site, EDP by EDP basis by Natural England, based on the cost of the relevant measures. But it's certainly a novel approach. I think industry, not just in housing, but in other sectors as well, has been crying out for some kind of strategic measure to be taken in order to unlock development, which has been held up by these kinds of things. So I think it's a courageous step. It did receive quite a lot of criticism around during the parliamentary debates about whether it was actually watering down environmental protection. And the honest answer to that is, well, let's wait and see. I think that those concerns were chiefly around, whether Natural England had the resource available to it in order to bring forward the environmental delivery plan program, and then to implement it and manage it effectively. And I think Natural England have acknowledged those concerns. But it seems that they are progressing with those schemes. At the back end of last year, there are indications that they're drawing up 23 environmental delivery plans to address some of these issues in various locations, chiefly focused in the southwest and the southeast. And consultations on those plans are likely to commence in the summer. So, they are starting those processes. Another one of the things that the King's Speech promised to deliver was reform to infrastructure planning, specifically around the nationally significant infrastructure project NSIP regime. Now, when I first started doing these projects 15 years or so ago, in practice, it would take about 18 months to get a project into submission. Over recent years, that process has ballooned to sort of 3 to 4 years often to get to that stage. Projects have become mired in pre-application consultations, with a concern that if you don't consult everybody on every change, almost, then the application won't get accepted for examination, and that's probably lead to an abundance of caution, but also the way in which stakeholders have responded to consultation. Obviously, sometimes they go into it with the aim of causing delay. So what the Act does is it will remove the requirement for statutory consultation around NSIP projects moving forward, and effectively leave it to the promoters of those projects to consult on a best practice approach, and it will publish guidance in due course around what that is. But the hope and aspiration is that will see an end to multiple rounds of consultation and elongated pre-application programs. And then the final bit I wanted to talk about, and it wasn't something that I was particularly trailed in the King's Speech, but it is interesting in terms of the way that it then feeds into some of the things that are raised in the NPPF, is setting up the structure for what will become strategic planning authorities. So the Act restores the framework for strategic planning by requiring combined authorities and combined county authorities to produce something called spatial development strategies. And those people who've been around in planning for as long as I have now might remember things called county structure plans and regional spatial strategies that we had under the last Labour government in the early 2000s. And part of the structural reforms that are being brought in is to see a bit of a restoration back to that strategic scale development planning. I think probably with less political interference and an overall aim to try and base development requirements and development decisions on assessments of need within regional areas. Those plans will then look to allocate quantums of development to local authorities to bring forward in their local plans, but without directing where precisely within those plans that will go. So I do think it's a bit of a return to strategic planning, and I think it's an acknowledgement that the localism agenda, which came in at the start of the 2010s, hasn't worked.
Thanks, Paul. I mean, I've heard you describe this before as sort of evolution rather than revolution, and I think that's sort of been borne out in what you've talked us through there. We'll move on to talk about the NPPF in a second, but when will the impacts of these changes, do you think, start to be felt by developers, and what can people be doing to make sure they're prepared?
Some parts of the Act, very limited sort of sections, will come into force at the end of this month, but the majority will require commencement orders and subsequent regulations in order to bring in those provisions. And a lot of the devil, as so often with these things, will be in the detail of those regulations. But look, the government's not going to hang about here because it needs to deliver. The problem, I think, often with the planning system is that it's a means. It's a means to an end. What the government wants to achieve is more houses being built or more clean energy generation being brought online. To get there, it needs to grant the planning permissions for those things. So, but its focus is on actually the back end and how it can get there quicker. So it will move fairly quickly, I think, on this.
Okay, thanks. So there's obviously a lot of change coming in via the new Act. And let's come on now to another round of change, which is the consultation on the NPPF. That was announced right at the end of 2025, just before the Christmas break. And it looks to me, as a non-planning specialist, like a pretty significant review of the current system is what's being proposed. So do you want to start with your sort of overall thoughts on this, the new draft PPF, NPPF, and how it's different and what difference it's going to make to the plans that are being developed?
Yeah, thanks. I mean, I think it is quite a lot different. And I think you can see that from the consultation document that accompanies the consultation draft. I mean, if I just sort of read out what that consultation document says was the aims of revising the NPPF, it's to make policy which contains more rules-based and certain systems. And so it's more capable of supporting timely and consistent planning, especially in those places where development is most desirable and where national policies should provide for a default yes to the principle of development. So again, we go back to is this something that's focused on delivery? Yes, it is. Is it something that's more rules based? Yes, it is. Is it trying to introduce something that's more predictable within the planning system, that if developers do X, Y, and Z or bring forward schemes in particular locations, then the result should be a consent at the end of it? It is trying to introduce that kind of system. And so again, I think it represents a return to a more sort of centralized directive decision making process. But just to go back to some of the things that's in there, and why is it different? The previous NPPF sort of had adopted a position of framing sort of relevant considerations and judgments, which it then left to decision makers to reach a conclusion on. What we're getting to now is a policy that says this is what developers must do, and when considering the particular impacts, often this is the amount of weight that decision makers should give to those impacts, and in certain circumstances when decision makers should refuse application. So it's a lot more directive. The other sort of key thing that it does is it separates out plan making policies from decision making policies. And those decision making policies are called national decision making policies. And the draft NPF makes it clear that the plan making policy shouldn't be a consideration in determining applications. So you can sort of separate out, if you're determining an application, what the policies are with the NPPF that you should be engaging with, and if you're making a development plan, what are the considerations that you should be looking at there. From a personal perspective, it's certainly easier to read, and it's certainly more user friendly as a result. It's worth just spending a minute to talk briefly about national decision making policies, because there was some discussion around whether these will be statutory. At the moment, they're not, but government says it's still looking at that. However, it's done everything but make them statutory. So, the draft NPF makes it clear that decision-making policies shouldn't be duplicated in development plans. It says that development plan policies which are anyway inconsistent with the national decision-making policies should be given very limited weight. And I think, what that's getting to is that, yes, these decision-making policies are ones which government expects to take primacy in many situations.
So in our last 5 minutes then, Paul, should we have a quick look at some of the specifics of the policies and what particular policies that you think are especially interesting?
Yeah, I'm going to focus on the big ones because we've only got a few minutes. Firstly, around the formulation of local plans, and it's worth people, if they haven't looked at it, to have a look at policy PM6, which sets out the general principles for plan making. There's a couple of interesting things in there in particular. Firstly, there's a statement that in preparing those local plans, local authorities should only include policies which extend beyond site or location specific requirements where they are necessary and where plan makers consider there is a clear and justified reason for inclusion. Now, what that means is government is telling local authorities to focus on policies which are relevant to their allocations and to move away from policies which sort of are generic countryside protection policies, those kind of things, and focus on the specific allocations. The other things that I wanted to highlight are around the presumption in favour of development. What the consultation draft said that the NPPF is trying to achieve is a permanent presumption in favour of suitably located development. And it does this in two ways. And again, people, if they want to have a look at this, should look at policy S4, which looks at how that presumption applies inside settlements, but perhaps more significantly, S5, which says how it applies outside settlements. Because outside settlements, it sets out a list of developments which should be approved unless benefits are substantially outweighed by impacts. And it's a fairly sort of limited list. And it says if you're not on the list, then you should be refused unless there are exceptional circumstances. But some of the couple of things that are on that are interesting that are on that list are developments of houses and mixed-use development, which would relate well to stations. So stations and well-connected stations, and the idea of clustering development around those stations is clearly a theme that government wants to drive forward in the way that plans and proposals are being brought forward under the new system. And secondly, outside settlements, bringing the ability to bring forward development which would address an evidenced unmet need. Now, that might be a shortage of housing land supply, or a failure to deliver housing under the housing delivery test as required, or an unmet need for other kinds of development. So I think the interesting thing for me is comes out through the role of stations. It's a sort of new element that we haven't seen the focus on in policy quite so much before.
Thanks, Paul, and some good tips there for particular parts of the draft NPPF for people to look at. So just to round off the PROPcast then before we end, there's obviously a lot of change in this area. There's going to be lots to do and lots to get to grips with. But is there more coming? Is there more change on the horizon, do you think?
Yeah, I think there is. I'm just going to say a couple of things, I think, in the time available. I think we can expect changes to Section 106 agreements. So the government's just published a policy paper examining ways and advising authorities to examine ways in which affordable housing, which is struggling to be disposed of, to revisit those measures and look at finding other alternatives so that those affordable housing measures can be brought forward. And I know that there is work ongoing on the production of standard form clauses for Section 106 agreements as well, which the aim of that is that will speed up the drafting and negotiation process around a lot of things. And then I think the other thing that is on the horizon, which wasn't addressed in the Act, but was certainly debated in Parliament during the formulation of it, is the introduction of measures to address what we call hillside issues. So issues of overlapping planning permissions, where there's the potential for a later drop-in application to frustrate the delivery or the further delivery of schemes under the original permission. So I think we can see something being brought forward to address that in the near future.
Thanks, Paul. I mean, there's lots to think about. We called this session "Planning for Change," and there's clearly, a lot of it about. So thanks very much. It's going to be very interesting to watch how all of these things develop. So thank you so much for joining me today and talking us through all of these upcoming developments. And thank you to everybody for listening as well. See you for the next Evershed Sutherland PROPcast. Thank you.
Thanks.